All right, let's proceed.
Thank you, Your Honor. Good morning. Your Honor, this lawsuit arises out of a real estate contract that the plaintiff in their petition specifically stated were parcels of land that were special and unique, and that the seller does not have an adequate remedy at law for damages, and that damages would be inadequate compensation. So they sued for specific performance. This comes out, we started in 2019, Your Honor, and had been litigating for at least 2 years out of the 2.5 years we've been pending in your court under this arrangement, where the plaintiff is suing the defendant for this remedy and only this remedy. We are before you on really two issues. Since 2019, we have been seeking the plaintiff's attorney billing statements. They produced them in the fall of 2019, and if you can see from my motion on at least half a dozen occasions that we have emails, and at least on 10 other occasions that I have phone calls, we have been trying to get them to supplement their attorney billing statements, because that's been the crux of this whole case in terms of us trying to get it settled or get it ready for trial. We have statements up until the fall of 2019 and nothing else. The statements that we have, Your Honor, and I've attached them to my motion, are almost 100% redacted. There is no way for me to conceivably determine if the attorney billing fees are reasonable or even prepare to cross-examine any counsel that would testify as to those fees. So we're asking the court to compel the plaintiff to produce unredacted billing statements and only redact the privileged and confidential attorney-client communications. The other thing, Your Honor, is we have found out in the summer of this year with the skyrocketing real estate prices that the plaintiff has now sold these two unique and special parcels of land. The plaintiff, although I've tried again on at least half a dozen occasions with counsel to get the real estate closing documents, or at least the contract or some idea as to what the plaintiff sold this land for, so we don't have this double dipping, or at least we have the plaintiff made whole. That has been rejected. They would not produce any form of contract. The reply that I just saw today saying that, oh, we have a non-disclosure agreement. Well, that's fine, Your Honor. I think if you order it, that'll give them sufficient cover to produce all of those documents. And that's what we found out about the sale, Your Honor, by us doing a search through the public records. Never been disclosed by the plaintiff. They've never supplemented their disclosure answers to either to give us a new damages model or to even give us the amount of attorney's fees they're seeking. The last point I'll make, Your Honor, with regards to the contract, I was going to share my screen, but it's in the defendant's response. They've attached section 15, which is the default provision in this real estate contract. And it's really unique and kind of changes the playing field for us now since they've done what they've done. Your Honor, the default provision basically says that if buyer defaults, and that's me, that's my client, they're saying we defaulted, we didn't close, then the seller's got an election of remedies. They got one of two things they can do. They can cancel the contract and get the earnest money, or they can sue for specific performance. Everything else is crossed out in this contract that's initialed. Those are the two options under the contract. And again, defense counsel has put that provision in their response. Till this date, Your Honor, this contract has not been terminated by the plaintiff. So we're still operating under the specific performance portion of the default. And if they elect now to terminate the contract, well, that changes the playing field. We litigating for 2.5 years their specific performance petition, Your Honor. Discovery is closed. We are set to go to trial, I believe, in December or January.
Is there an injunction in place that keeps them from selling?
No. And they've already, well, we have not filed a les pendants, and you have not signed an injunction, Your Honor, to prevent them. We haven't sought it. We wouldn't seek it because we were being sued for specific performance. They were trying to force us to buy this land. Then they went and sold it from underneath your feet and our feet and everybody's feet, and they won't tell us what they sold it for. Your Honor, if they sold this land, our contract was for, I believe, 650. If they sold this land for 700 or 750, well, that violates all kinds of things that they can't come back and sue my client now saying, oh, we have a contract for 650, but we sold it for 750, but we still want
Are
more.
you suing for specific performance, or are they suing specific performance?
They are, Your Honor.
Okay.
That's no longer the case, Your Honor, but I'll wait for my response.
All right, Mr. Ahmed, Ms. Ahmed, I'm sorry, go ahead and proceed.
It's okay,
Well,
Judge.
one last thing, Your Honor, if you'll allow me.
Go ahead.
Your Honor, since 2019, we have been seeking the attorney billing statements, and since we found out in late summer, we've been seeking these sales documents. I've attached my 6 emails on either topic, and I think it's only fair that if you look at my motion, we have been trying to do this from the fall of 2019. So it'd only be fair that my client be reimbursed their attorney's fees. And we're seeking, Your Honor, I've got 7 hours in this. My billing rate is $450. So we would humbly ask the court that to have this plaintiff at least live up to the standards that all of us other lawyers are, and my client be reimbursed the $31.50 that he's expanded in trying to get these 2 vital pieces of information. Thank you, Your Honor.
May it please the court, Your Honor. First of all, Your Honor, if I can just share my screen so I can just show you the default provision that the Plaintiffs' Counsel mentioned.
Go ahead.
Thank you, Your Honor. Okay, there it is. And I'm going to zoom in, Your Honor. So, Your Honor, we filed this lawsuit back in 2019 because on the eve, within days before the closing of the sales transaction, defendants sent a letter through his attorney that he no longer wishes to purchase these properties, and so in accordance with the default provision that's that you see before you, we've asked, we initially asked for specific performance because at that time, my client owned both properties, but we've never asked for, but we've always limited our remedies to what is, to what we are entitled to, which you can see, Your Honor, which is either the earnest money as liquidated damages or specific performance. Both parties crossed out the remaining or seek such other relief that as may be provided by law. So, Your Honor, after we're no longer seeking specific performance due to the sale, but now which now entitles us to just liquidate the earnest money as liquidated damages. So here we're not suing defendant for any other for actual damages. The parties agreed, they negotiated and agreed that in case if defendant breaches, then it's going to be liquidated damages, the earnest money, or specific performance. And again, specifically non-suited it due to the sale. In addition to that, Your Honor, so plaintiffs can't even hasn't explained how the February 2021 sales, the 2021 sales documents are relevant.
I agree that if the only remedy at this point is the earnest money, I'm not sure why the sales documents would be relevant. Mr. Hamida.
Again, Your Honor, it's to make the plaintiff whole. The whole damages model that they have brought before you is to make the plaintiff whole. If under this contract, all right, I see where the court's going, Your Honor. If they're changing the rules in the playing field and now reverting back to just the earnest money, then, Your Honor, they haven't terminated the contract, not by writing, not by lawyer, not by client, not by anybody. We are still under your live pleadings that are before you, Your Honor, still say that they're suing my client for specific performance. And if now they're going to change the plaintiff, really the technically
have you non-suited, Ms. Ahmed? Have you non-suited your claim for specific?
Defense counsel failed to mention that we non-suited specific performance. I believe, Your Honor, back in May. As soon as, so after the sale, we non-suited specific performance. Specific performance is no longer in the picture, Your Honor. And even if there was specific performance, Your Honor, there are many Texas decisions out there that mitigate, that separates, liquidated damages, specific performance from actual damages, such as, and that's not the case here, Your Honor. We're only limited to two things: either the earnest money in return as liquidated damages plus attorney's fees upon prevailing. And Your Honor, as for our attorney's fees, we will supplement. We have produced initially, just like defense counsel has, but we're a separate trial right now on January 11th. We will supplement accordingly, Your Honor. We have responded to all the requests, for the discovery responses timely, pursuant to the parties' Rule 11 agreement back in 2019. And so, Your Honor, this is, we have been acting in good faith and producing what we can and what we have. And again, if we've not suited specific performance. So with respect to the sales documents, it's not relevant, and therefore it's frivolous, and it's also harassing. Again, because it doesn't relate to our claim or to their defenses.
Yeah, it looks like Jamie O'Farrill, there you are. They did non-suit back in May, the specific performance claim. So I'm going to go ahead and submit. I'm going to order you guys to produce an unredacted version of your attorney's fees at least 30 days before trial, and then supplement those at trial. So go ahead and prepare an order on that, Mr. Hamida. I'm not going to order there to be any type of attorney's fees, and I'm not going to order you to produce the sales documents. Okay, guys.
I'm so sorry, Your Honor. Just to clarify, you said unredacted.
I said redacted.
Okay, thank
versions.
you.
I'm sorry if I said unredacted. I meant you can take out any attorney-client privileged information.
Thank you, Your Honor.
Okay. Anything else, guys? So, Mr. Hamida, go ahead and prepare an order for me. Make sure the order says this hearing was heard on October 4th, 2021. Share a copy of the order with Ms. Ahmed, and email it to my court coordinator, as well as go ahead and e-file it. Okay.
Will
Thank
do.
you, Your Honor.
Thank you, Your Honor.
Thank you. You guys have a great day.
You
Thank
too.
you,
Thank
too.
you, Your Honor.
Okay. Bye-bye.
Bye-bye.
Okay. Mr. Ricci, are you here for the 11:15 hearing?
Yes, Your Honor.
Okay.
And I do believe it will just be me.
Okay.
If I may proceed.
You may.
Your Honor, I represent Kristen and Craig P.S. This was a severed out defendants from the main case. We had a default judgment entered against them, and we're severing them out so we can get that interlocutory order into a final order. We have been unable to serve the defendants, Real Deal Advisors and J. Tyler Wine. We've made attempts on multiple locations on them, and I believe this hearing is set because of the affidavit of our process server saying that there is a different business at that current location.
Yeah, so the issue I had was, in order for us to do a subservice, we need to know that you have the right address, and it didn't appear that you had the right address here.
I honestly don't know which address they're at. I used all the addresses that I had access to, either through the Secretary of State's website or the...
So you can serve them through the Secretary of State at the registered address. If they've moved, that's their own fault, but you can't do subservice if you don't know that's the right address. So you can serve them through the Secretary of State, get a Whitney certificate, and then, but I don't think subservice is the proper remedy.
Forgive me, Your Honor. I don't believe this party is actually registered with the...
Oh, I'm sorry. You said they were
that's my fault. There's so many defendants in this case and so many different moving parts. This party was never registered with the Secretary of State when I looked. We have been e-serving them through his email, J. Tyler Wine's email, and it's
Okay.
on in both cases. I also have his Twitter account information, which I'm with the
So
new
you
rules.
know, under the new rules, you can do a subservice request for that, but there's certain requirements you have to do first, in order to, you can look at the rules for that. But I think what you requested for us to serve at a particular address, if you don't know the right address, then that wouldn't be appropriate. So I think you need to, maybe I'm wrong about this, but my recollection of this is that you just asked to serve at a particular address. So you would just need to file a new subservice and prove it up to the requirements of the new rule.
Okay, so you're requesting that I prove up the new rule in regards to the electronic service by social media.
I'm not requesting that. I'm just saying if you want to get it granted,
Okay.
That's the only point I'm making. I'm just trying to help you out. So
I appreciate that, Your Honor, and I will get that motion on file with a revised order. Are we going to need to have another setting on that, or is it going to be able to be?
Look, if there's not a problem with the subservice, 90% of these I grant without any type of hearing.
Okay.
If there's some kind of issue that I need to talk to you about, then I'll set another hearing. I think we requested this hearing, if I recall correctly, because there was
That
an
is
issue with the subservice. So yeah, if there's not an issue with the subservice and it complies with the rules, I'll sign it without but you do have a DWAP docket coming up in November. So you want to try to get this on file as soon as you can.
Right. We'll hopefully get something on file by the end of the week at the latest and get that to you and go from there, Your Honor.
Sounds good. Anything else?
Awesome. Nothing further, Your Honor.